One of the supposed benefits of capitalism is the right to go on strike and negotiate with the capitalist. This, they say, is one of the positives of the free market. However, there is a case in the Supreme Court right now that would end much of that. There is a lawsuit before the Supreme Court, Glacier Northwest Incorporated v. International Brotherhood of Teamsters. Essentially, the company wants to sue the union for damages. The workers had been without a contract for months, and this failure to reach an agreement caused them to walk off the job. The alleged damage was from union workers parking their cement trucks in the parking lot of the company during the walkout. The cylinders were kept running to prevent the cement from drying. After a week, the cement had still dried out. The employer was responsible for ensuring that the cement was either removed or delivered to customers. According to the company, the cement had to be washed out of the trucks and was rendered unusable, costing them roughly $11,000. Afterward, the company filed suit against the union for those losses. They claim the Teamsters went on strike intentionally to cause that damage. According to Passage, this is what's known as a Garmon preemption, forces an employer to obtain a ruling at the National Labor Relations Board saying that what workers did during the strike is not protected activity under the Federal National Labor Relations Act before it can file a lawsuit for damages in court. This effectively means that the federal agency tasked with protecting workers' rights has preemptive power to make such determinations before any case can proceed in state or federal court. Lawyers for the Teamsters maintain the employer's tort claim was unlawful because the union engaged in NLRA protected activity, an opinion with which the Washington Supreme Court agreed. During the first round of the lawsuit, the Washington Supreme Court ruled that their actions did not violate the NLRA's protected activities. The judges ruled unanimously to dismiss the lawsuit. The company has since then appealed to the federal Supreme Court. The court is packed with a right-wing supermajority that would be able to determine the fate of every job action that takes place in the future. An employer would be able to sue the union for lost revenue during any strikes. Such a move would bankrupt many of the smaller unions and possibly cripple the larger ones. As it is, it's a major game to go on strike in the current labor conditions of the United States. This would make it exponentially worse. Right now, a radical liberal is in the White House, which means he won't be of any help. Previously, U.S. President Joseph Biden falsely claimed to be the most union president ever. His choice for labor lawyer, Jennifer Abruzzo, as general counsel has been dismal. Her positions have been walking the line between capitalists and the written rights of workers. As Passage notes, what counsel for the government are essentially saying is that the NLRB has preemptive authority to determine what workers' actions are protected by federal law, and that, in this case, they should be able to determine this before any lawsuits proceed. Insofar as this intervention on neither side seeks to uphold Garmon, it's welcome. But, to put it frankly, counsel for the NLRB and the Biden administration seem much more concerned with protecting federal preemption and the jurisdiction of the labor board than with protecting the right to strike or defending the interests of the workers in this particular case. This action is being heavily supported by the usual anti-labor suspects: the Chamber of Commerce, the National Federation of Independent Businesses, the State Policy Network, and the National Right to Work Legal Defense Foundation, all of whom have sought to overturn all legal protections and rights workers have. This is a very dangerous time for workers' rights in America. Very slowly, the rights of the American people are being peeled away under the progressive guise of Biden and other radlibs. This current Supreme Court has already violated the rights of women by overturning Roe v. Wade. This is capitalism, but the capitalist wields the state power. The ability to bankrupt and destroy unions is coming very soon. Thank you for watching. If you like this program, then please head over to my Patreon page and set up a monthly donation. It's your donations that keep this program running. Also, if you would like, please rate, comment, subscribe, and share in various social media.